To tell us more about Rex Education and to officially open today's event, let us hear from Rex Education's Chief External Affairs Officer, Ms. Danda Cremelda I. Buhayin.
Good afternoon and welcome everyone. We are excited to be with you all today as we join the countdown to the 2021 bar examinations, the first of its kind, taken digitally across several local sites across the country. Law has always been close to the heart of Rex Education. Throughout our 70 years of service and dedication to education, law books, bar exam reviewers, and legal learning companions have always been at the core of our products and services. Now that Rex has evolved from the iconic bookstore that we all know to something bigger and more significant, we are honored to serve even better every aspiring and practicing lawyer in the country. True to our tradition of service, Rex Education is guided by the Educampion philosophy, which seeks to rally and empower education duty bearers. An Educampion is a champion for education who works with the best interest of the Filipino whole learner in mind. Many of our legal students who will be taking the bar exams are Educampions themselves. As students of law, they experience firsthand the needs of the education sector, and as future lawyers, they will help mold and shape the country's legal landscape for the good of the next generation of students and lawyers. This is the legacy of Rex Educampion agenda, and this is the legacy of education and service that we want to celebrate with all of you today. Because of this, we are excited to spend the next 2 hours with you as we now unveil our most updated offering of the Philippine legal community, the pre-week Handbook on Labor Law. Written and published especially for this year's bar takers and designed as a last-minute reading material, this book presents the basic legal principles which every labor examinee ought to remember. The authors of this impressive review material believe that excellent understanding of the basics sets a strong foundation in learning in advance, and they hope that this material can help this year's bar examinees achieve their dreams of becoming not just a lawyer, but genuine servant leaders that will guide this country to prosperity, justice, and goodness. It is with great pride that I present the honorable father and son tandem who were the great minds behind this book. Attorney Paulino Ungos Jr. has been a labor practitioner for the past 47 years and is currently a labor law professor and a labor consultant at Globe Telecom. His son, Attorney Paulino Q. Ungos III, has been a labor practitioner for the past 17 years and is currently a law professor and the commission attorney of the National Labor Relations Committee. Friends, join me in welcoming our partners in championing legal education, Attorney Paulino D. Ungos Jr. and Attorney Paulino Q. Ungos III.
Thank you for that wonderful introduction. Just like law practice, bar exams involve application of the general principles that we have learned in law school. Therefore, in answering bar examination questions, the examinee must be guided by the applicable legal principles. So a working knowledge of the legal principles will greatly help in answering bar examination questions. Now, this book addresses that concern. Now, it can be assumed that every bar examinee has already read the basic textbook while reviewing for the bar exams. But during the examination week, it is neither practical nor feasible to be reading the basic textbook again. Now, the book is designed to be a last last-minute reading material for bar examinees. So the book contains the basic principles which every bar examinee ought to remember, bearing in mind that bar examination principally involves application of legal principles. Now, when I took the bar exams decades ago, our Dean Feliciano Hover Ledesma, advised us to stick to the basics, which he reiterated during our last-minute breakfast meeting before going to the examination site. Now, this work follows the said advice. Now, if you will go over the contents of the book, you will notice that the book is divided into short chapters. The purpose of this is to enable the examinee to facilitate the search for topics which they want to further familiarize. So let us now discuss some topics which can be the source of tricky questions. The different bars to a certification election. First, we have the contract bar rule. Contract bar rule. And what does the contract bar rule say? The contract bar rule says that a duly registered CBA will bar the filing of a petition for a certification election. Article 238 says that the Bureau shall not entertain any petition for certification election or any other action which may disturb the administration of duly registered existing collective bargaining agreements. Now, so if the provision would be analyzed, it can be readily seen that not every registered CBA will bar the filing of a petition for certification election. Only a duly registered CBA will bar the filing of a petition for certification election. And a CBA is duly registered if all the requisites for registration have been complied with. If the parties were able to register their CBA without complying with any of the requisites for registration, the CBA is not registered. And what is the significance of that? A registered CBA but not duly registered. But the significance is that it will not bar the filing of a petition for certification election by any union. In short, the majority representation of the incumbent certified bargaining agent can be validly questioned through a petition for certification election. So what would be an example of registered CBAs that are not duly registered? One would be a CBA that was registered without complying with the posting requirement. remember that after the CBA is signed by the officers of the union and the representatives of the management, it has to be posted for 5 days in 2 conspicuous places in the establishment. The purpose of that is to inform the employees covered by the bargaining unit about the contents of the CBA, so that they will be guided on whether to ratify it or not. So if the posting requirement was not complied with, and the parties, despite that deficiency, was able to register the CBA, then the CBA is not duly registered, which means that any union can challenge the majority representation of the incumbent bargaining agent. Another example is a CBA that was hastily entered into prior to the 60-day freedom period. You will recall that a CBA, a notice to terminate the CBA, can be done only during the freedom period. Now, if the parties, without waiting for the freedom period, entered into a CBA and they were able to register the CBA, then the CBA is not duly registered. Another example would be a CBA that was entered into with a labor union or labor organization that has not been certified as the bargaining agent. Under the present rule, a labor organization must be certified as bargaining agent, certified by the Department of Labor and Employment. Unlike before, where voluntary recognition was allowed, but under the present setup, voluntary recognition is no longer allowed. So that means that if the employer merely recognized the union voluntarily and then they entered into a CBA, which they were able to register, the CBA is not a duly registered CBA. So that means that any union can challenge the majority representation of the incumbent bargaining agent. The next bar to a certification election is the election year bar rule, which says that a petition for certification election cannot be filed or entertained within 1 year from the holding of a valid certification election. Just remember that the election year bar rule presupposes an actual election and that the election was valid as distinguished from failure of election. A case in point here is the art transport case. Now, in the art transport case, the union filed a petition for certification election, but the med arbiter dismissed the petition for failure to comply with the documentary requirements. So what the union did was to file a second petition, this time with complete supporting documents. Now, the employer moved for the dismissal of the petition, invoking the election year bar rule. So the issue there is, was the union barred from filing the second petition? Stated otherwise, was the employer correct in invoking the election year bar rule so as to prevent the holding of a certification election? the Supreme Court ruled that the election year bar rule will not apply because there was no election conducted. What happened was that the first petition was merely dismissed. So the election year bar rule will not apply. The third bar to a certification election is the negotiation year or certification year bar rule, which says that no petition for certification election can be filed or entertained within 1 year from certification as collective bargaining agent. The 1 year period here does not necessarily is not necessarily reckoned from the date of election, but from the day of certification as bargaining agent. What is this 1 year period for? The 1 year period is the period allotted to the union, to the certified bargaining agent, to initiate the CBA negotiations. So if the 1 year period lapses without the union negotiating a CBA, then the certification year bar rule will not apply anymore. Case in point, the case of Campil versus Trajano. The union was certified as the exclusive bargaining agent of the rank and file employees of the company. Now, 4 years had lapsed without any bargaining negotiations between the parties. Now, a new union filed a petition for certification election. The question is, will the petition prosper? Well, the Supreme Court ruled that it will prosper because the 1 year period within which to negotiate a CBA has already lapsed. Next is the Deadlock Bar Rule. Deadlock Bar Rule, which says that no petition for certification election can be filed or entertained when the CBA negotiations that resulted in a deadlock have been submitted to conciliation, arbitration, or is the subject of a valid notice of strike. Now, there was the case of Nakusik versus Trajano. The CBA negotiations between the union and the company resulted in a stalemate deadlock, after which they submitted the deadlocked issues to voluntary arbitration. Now, 1 month after the submission of the deadlock to arbitration, a new union filed a petition for certification election on the ground that despite the lapse of more than 1 year, the parties have not concluded a CBA. Now, the question is, will the petition prosper? The Supreme Court ruled that the petition will not prosper because the deadlock has already been submitted to arbitration. Let us move to another topic: strikes and lockouts. Also a favorite of bar examiners. Now, if you are confronted with a problem on strikes, just remember the elements of a strike. So if the question is there a strike? To answer that, consider the elements. What are those elements? Well, first, there must be stoppage of work. Second is that the stoppage of work must be concerted, temporary, and the result of a labor dispute. So the first point that you should consider is that there must be stoppage of work. That is why if the employees establish themselves at the gates during their 1 hour lunch break, holding placards to inform the passers-by about their labor dispute with their employer, there is no strike, considering that it is their lunch break. There is no work during lunch break, and therefore there is no stoppage of work. The second point that you should consider is that the stoppage of work must be concerted. The concerted stoppage of work may take the form of walkout, mass leave, sit down, and similar activities, such as the concerted violation of the hotel's grooming standards. Third point, the stoppage of work must be temporary. That is why mass leave arising out of a labor dispute is a strike, because mass leave is a concerted action that resulted in temporary stoppage of work. But mass resignation is not a strike, even if it arose from a labor dispute, because the stoppage of work, although concerted, is not temporary, because resignation permanently cuts off the employment relation. Next is that the stoppage of work must arise from a labor dispute. What is a labor dispute? It is a controversy pertaining to terms and conditions of employment, as well as or including representation of workers. So the stoppage of work must arise from a labor dispute. That is why the refusal of employees to work because they will join the mass demonstration in protest of police abuses is not a strike, even if there was a stoppage of work, and even if the action is concerted. The reason is because the concerted action did not arise or did not result from a labor dispute, but because of a protest due to police abuses. But if employees join the Welgang Bayan, then there is a strike. Remember the case of PhilFlex. There was a time when the labor sector staged a Welgang Bayan, affecting so many companies. The strike lasted for several weeks. Now, the reason for the strike was to protest the accelerating prices of oil. Now, so the companies dismissed the strikers. Now, the unions argued that their activities cannot be considered as a strike because there was no labor dispute. Because their strike was in protest of the accelerating prices of oil. But the Supreme Court ruled that the Welgang Bayan is a strike, a general strike, and therefore illegal. So another topic which can be the source of tricky question is this: who can declare a strike? The answer is only a certified collective bargaining agent can declare a strike, with emphasis on certified. Certified, which means that the union must have undergone the certification process. So only a certified bargaining agent can declare a strike. But suppose there is none, there is no certified bargaining agent. Well, if there is no certified bargaining agent, a strike can be declared by a legitimate labor organization on the ground of unfair labor practice. Again, with emphasis on the word legitimate. Legitimate. A legitimate labor organization is one that is registered with the Department of Labor and Employment. So that means that an unregistered union cannot strike even if the employer committed unfair labor practices. Also, a union whose registration has been cancelled with finality cannot strike, because cancellation of registration with finality renders the or divests the union of its legitimacy and legal personality. And another point that you should consider is that if the establishment has no union, the employees thereat cannot strike. So if there is no union, the employees cannot strike, because, as stated earlier, only a certified collective bargaining agent can declare a strike, or if there is no certified bargaining agent, a legitimate labor organization can declare a strike on the ground of unfair labor practice. Now, next, legal grounds. There are only two legal grounds for declaring a strike. The first is collective bargaining deadlock and unfair labor practice. Now, so if you are confronted with a problem regarding validity of a strike, determine the ground. Was it because of CBA deadlock or unfair labor practice? Aside from the two legal grounds, there are mandatory requirements that must be complied with by the union. The first is notice of strike. Second is strike vote. And the third is strike vote report. So a strike without complying with these requisites is illegal. In the same manner that a strike declared on grounds other than collective bargaining deadlock or unfair labor practice is illegal. So if you are confronted with a problem regarding validity of strikes, the problem may state that the mandatory requirements were complied with. Merong notice of strike, strike vote, and strike vote report. But go further. Determine the ground for the strike. Because there may be that the union may have filed a notice of strike, they have conducted a strike vote and submitted a strike vote report. But if the ground for strike is not unfair labor practice or collective bargaining deadlock, the strike is still illegal. So, a notice of strike is a mandatory requirement. What is the purpose of the notice of strike? Well, the purpose of the notice of strike is to provide for a cooling off period. This is a source of tricky question. Article 278 says that in case of dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which constitute union busting, where the existence of the union is threatened, the 15-day cooling off period shall not apply, and the union may take action immediately. There are 2 points that you should consider in that provision. The first is that the dismissed officers must be elected, not appointed. So watch out if the problem says appointed. Now, the cooling off period must be observed. Now, second point that you should remember is that the dismissed union officers must be duly elected. Again, take note of the word duly elected, which means that they were elected in accordance with the Constitution and bylaws. If the election did not follow the Constitution and bylaws, then the union officers are not duly elected. This mandatory requirements should still be complied with in case of union busting. You will note that even though the union, in case of union busting, is given the authority to immediately strike without exhausting the cooling off period, it is still obliged to comply with the mandatory requirements of a strike, which means that the union should still file a notice of strike, conduct a strike vote, and submit the strike vote report. In short, in case of union busting, only the cooling off period is dispensed with, not the compliance with the mandatory requirements. So, if a strike is declared illegal, the union officers who knowingly participated in the illegal strike may be dismissed. What would be an example of an illegal strike? Well, first would be a strike without complying with the mandatory requirements, the notice of strike, strike vote, and strike vote report. Or a strike declared on grounds other than collective bargaining deadlock or unfair labor practice. Sometimes during a strike, illegal acts are committed. Now, what are the consequences for committing illegal acts during the strike? Well, union officers or plain members who committed illegal acts during the strike may be dismissed. Now, illegal acts. Example of illegal acts would be obstruction of the gates of the company or committing acts of violence or with defiance of return to work order. Those are illegal acts. National interest disputes. Under the law, in disputes causing or likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor is empowered to assume jurisdiction over the dispute and decide it, or certify the dispute to the NLRC for compulsory arbitration. Now, so, if the Secretary of Labor assumes jurisdiction over a labor dispute or certifies the dispute to the NLRC for compulsory arbitration, a strike or lockout, whether actual or intended, is automatically enjoined. So what does this mean? Well, it means that the strikers must return to work and the employer must put an end to the lockout. And the employer must readmit the strikers or the locked out employees under the same terms and conditions before the strike or lockout. Now, readmit all workers. What does it mean? Now, the workers who can be readmitted are only those strikers who did not commit illegal acts during the strike. Now, how about the phrase under the same terms and condition prevailing before the strike or lockout? Well, this contemplates actual or physical reinstatement and not payroll reinstatement. Although in some exceptional cases, payroll reinstatement may be resorted to, especially when actual or physical reinstatement is rendered impracticable. A case in point here is the USD case, where the teachers were placed on payroll reinstatement because the teachers cannot be given back their teaching assignments because the return to work order or the assumption order was issued in the middle of the semester. So it is not feasible anymore to physically reinstate them. Another example would be the case of Dusit Hotel. Remember that in the Dusit Hotel, the waiters reported to work with shaven heads, nagpakalbo. Now they cannot be ordered reinstated because they cannot be ordered physically reinstated precisely because they were not allowed to work because they violated the grooming standards. So they were placed merely in the payroll. So what will happen if strikers defy the assumption or certification order? Well, all strikers, whether union officers or plain members, may be declared to have lost their employment status. Okay, let's move to another topic. The procedural requirements for dismissal of employees. There are two aspects. One is dismissal for just cause and dismissal for authorized cause. Now, let's first discuss the due process requirements for dismissal for just cause. Well, under the rules, under the law, employers are required to issue a written notice to explain or conduct a hearing if necessary and issue a written notice of decision. Now, the notice to explain must be in writing and should specify the acts or omissions committed by the employee. A general statement as to the offense will not suffice. No. And the notice to explain should also give the employee reasonable period within which to explain. What would be a reasonable period? Well, in the case of King of Kings Transport, the Supreme Court ruled that a minimum of 5 days is a reasonable period. If the continued presence of the employee poses a serious and imminent threat to the life and property of the employer or of the co-employees, the employer may place the employee under preventive suspension. The purpose of this is to prevent the employee from causing harm or injury to the company, as well as to his fellow employees. Now, administrative hearing. Well, administrative hearing may be conducted only when necessary. And if ever an administrative hearing is conducted, it is summary in nature, and it is not a matter of right. In fact, confrontation of witness is not essential because confrontation of witness is required only in adversarial criminal prosecutions and not on company investigation. So that means that an employee cannot claim denial of due process if he was not given the opportunity to confront his witnesses. Employees need not even be apprised of the right to counsel because the right to counsel, the obligation to apprise a person of the right of counsel applies only to custodial investigation and not to company investigations. That is why an employee cannot claim denial of due process if he was not apprised of his right to counsel. Then the next is notice of decision. The decision must be in writing, indicating the penalty for the offense, or exonerating the employee if the evidence does not prove any culpability. Now, in either case, the justification for the decision must be stated. Let us now go to the due process requirements for dismissal for authorized cause. Yung authorized cause, this refers to dismissal because of introduction of labor-saving devices, redundancy, retrenchment, and closure of business. If employees are dismissed for any of those causes, the law mandates the employer to serve a written notice at least 1 month in advance to the affected employees and to the Department of Labor and Employment. Now, the notice to the affected employees must be served personally. Mere posting in the bulletin board is not substantial compliance. And 1 month notice must also be strictly complied with. So if the notice merely gave 15 days or merely advised the employee that his services will be terminated after 15 days, then there is no substantial compliance with the notice requirement. So this brings us to the question of what would be the effect if the employee was dismissed without observance of the due process requirement. But under the present rule, if the dismissal is adjudged to be illegal or valid, if the dismissal is adjudged to be valid, the employer is liable only for nominal damages. In short, the failure of the employer to give due process or to comply with the due process requirement does not render the dismissal illegal or ineffectual. The dismissal remains to be valid, but the employer is liable for nominal damages. Let us summarize the liabilities regarding due process. Now, just remember this. If the dismissal is adjudged to be valid, but the due process was observed, no liability. The employer has no liability. But if the dismissal was valid, but due process was not observed, the employer is liable only for nominal damages. But if the dismissal was adjudged to be illegal with due process, the liability is reinstatement with back wages. Remember, because if the dismissal is illegal, the relief is reinstatement with back wages. So even if due process was complied with, the employee concerned is entitled to reinstatement with back wages if his dismissal is declared illegal. The same, if the dismissal is declared illegal but without due process, the same, reinstatement with back wages. Let's now go to the prerogative of employers to promulgate rules and regulations. We have the no spouse employment policy. A company policy prohibiting employees from marrying employees of competitors is valid because employers have the right to safeguard their manufacturing formulas, trade secrets, or marketing strategies. Because what is sought to be avoided is conflict of interest that may arise out of the relationship. The Glaxo case is in point. Glaxo is a pharmaceutical company. Now, there was this detail man employed by Glaxo who had a relationship with another employee of a pharmaceutical company, also a detail man. Eventually, they got married. So Glaxo informed the employee for him to choose on who of them should resign from their employment. But the Glaxo employee refused to resign. Neither did she persuade her wife to resign. So instead, the Glaxo employee questioned the validity of the policy. Is the policy valid? The Supreme Court ruled that the policy prohibiting employees from marrying employees of a competitor is valid. Another policy which may be promulgated by employers is the Anti-Nepotism policy. Now, what is an anti-nepotism policy? Well, this is a policy which prohibits spouses from working for the same company. Is a anti-nepotism employment policy valid? Well, it may or may not be valid. So how do we determine whether the anti-nepotism policy is valid? Well, we apply the reasonable business necessity rule, which means that the employer must prove that the policy is founded upon business necessity and not just on the perception that the spouses in the same workplace might affect adversely the business. The employer must show how the marriage could be detrimental to the business, and not just on the fear that employees married to each other will be less efficient. In the Star Paper Corporation case, involved were two ordinary rank and file employees. One is a machine operator, and the other is a repacker. So they married each other. Now, after their marriage, the employer told them that one of them should resign pursuant to the company policy. So the employees challenged the validity of the policy. So the issue there in this specific case is whether the policy of Star Paper Corporation prohibiting spouses from working in the same company is a valid exercise of managerial prerogative. And the Supreme Court ruled that the validity should be looked from the business, from the reasonable business necessity rule. Now, the employer here in this case failed to prove that that there was a reasonable business necessity for the policy as applied to these two employees who are mere rank and file workers. So in this case, the Star Paper Corporation failed to prove or to show how the marriage could be detrimental to its business. Next is the non-compete policy. Non-compete. A contract which prohibits an employee from engaging in a business or employment competitive with that of the employer after the term of employment for a given period is valid. If the restraint is imposed, if the restraint imposed is not greater than what is necessary to afford reasonable protection to the employer, and the contract provides for a limitation as to time or place. This is common in big corporations, especially executives. They cannot just transfer to a competitor within a certain period. In one case, the employee who had an insight into the general scope and details of the business was prohibited from engaging in a business or employment for a term of 5 years from termination of his employment. And the Supreme Court ruled that the prohibition is valid. In another case, the employee was prohibited from engaging in business or employment, any kind of business or employment, in any establishment in the Philippines for a period of 5 years from termination of his employment. the Supreme Court ruled that the non-compete agreement is not valid because it does not provide for a limitation in fact, there is a restraint on his employment. Imagine the employee was prohibited from engaging in any kind of business anywhere in the Philippines. So the Supreme Court ruled that that is not a valid agreement because it embraces all kinds of business or employment anywhere in the Philippines. Next, layoff of employees. Layoff, this is just a temporary separation from service brought about by suspension of operations or temporary closure or fulfillment of a military or civic duty. An example of layoff is a security guard who is placed on floating status because the employer has not found any client where he could be posted. No. So, what is the legal consequence of temporary closure? Consider 2 points. Determine whether the closure was done in good faith or in bad faith. If the temporary closure was done in good faith, the employment status is not terminated, but merely suspended. So, if the employer resumes operations, then the employer must restore or reinstate the employee to his former position without loss of seniority rights, provided that he expresses his desire to work not later than 1 month from resumption of operation. So, if in good faith, the employment status is suspended. But if the closure was done in bad faith, the employment relationship is deemed uninterrupted. In short, no suspension. So for how long can an employer temporarily close its business? Well, under the law, temporary closure, whether done in good faith or in bad faith, should not exceed 6 months. Otherwise, permanent closure will ensue and the employment relation will automatically terminate. That is why if a complaint for illegal dismissal is filed within the 6-month period of temporary closure, the complaint is premature. Suppose the closure exceeds 6 months. What would be the entitlement of the employees affected? Remember that if the closure exceeds 6 months, there is automatic termination of employment. So what would be the entitlement of the affected employees? Again, determine whether the temporary closure was done in good faith or in bad faith. If the temporary closure was done in good faith, the affected employees will be entitled to separation pay of at least 1 month pay or 1/2 month pay for every year of service, whichever is higher. Unless, of course, the closure was due to serious business losses, in which case the employees are not entitled to separation pay anymore. But if the temporary closure was done in bad faith, the affected employees are entitled to their wages during the 6-month period of closure and to separation pay of at least 1 month pay or 1/2 month pay for every year of service. Now, but notwithstanding the bad faith of the employer cannot be compelled to continue with the business because that would be oppression. Now, this brings us to the question of can the 6-month temporary closure be extended? This is a new rule which was promulgated during this pandemic situation. Under the new rule, in case of declaration of war, pandemic, or similar national emergencies, the employer and the employees may agree through their union, if any, or with the assistance of the Department of Labor. They may agree to extend the temporary closure for another 6 months. So you will notice that the employer has already closed its business for 6 months. Now, here the employer and the employees may agree to extend the closure for another 6 months. So 1 year na. What will be the effect if the temporary closure is extended for another 6 months? Because consider the length of temporary closure, the employees may find employment elsewhere. Now, if the employees were able to find alternative employment during the extended temporary closure, what happens? Are they deemed to have abandoned their employment? The answer is no. If the employees find alternative employment during the extended temporary closure, the employment status remains suspended. To cut off their employment relation with the old employer, they should resign voluntarily and unequivocally in writing. But suppose the employer during the extended period decides to reduce its personnel, what would be the effect? Well, under that situation, the employees will be entitled to their separation pay as prescribed by the Labor Code, which is at least 1 month pay or 1/2 month pay for every year of service. So, under that situation where the 6-month temporary closure was extended, how do you compute the length of service? Well, under the new rule, the first 6 months of temporary closure will be included in computing the length of service, even though the employees did not render any service during that 6-month period of temporary closure. If the employer resumes operations, the retrenched employees shall have priority in rehiring. So that is about layoff. Now, another point is the service incentive leave. You see, claims for service incentive leave is a money claim. Now, a question may arise as to the prescription of service incentive leave. Ordinarily, money claims prescribed in 3 years from the time the cause of action accrued. But when it comes to the prescriptive period for service incentive leave, the reckoning of the prescription or the prescription is still 3 years. 3 years per because it is a money claim. But when do we reckon the 3-year prescriptive period? Well, the 3-year period is reckoned from the time that the employer refuses to pay its monetary equivalent or upon termination of employment. So why is that so? Well, the reason is because service incentive leave is cumulative if unused. Because the employee has the choice to choose on to use the service incentive leave or to get its cash equivalent. Now, suppose the employee does not avail of these two options. The service incentive leave will accumulate. And the employee can get the accumulated service incentive leave upon termination of his employment. So that means that if the employee did not get the cash equivalent of his service incentive leave for 10 years, the employee can still recover the 10-year service incentive leave. And the prescription will run only from the time that the employer refused to pay its monetary equivalent or upon termination of employment. I guess that would be all. I am now open to questions.
Thank you very much for that very rich presentation, Attorney Paulino Ungos Jr. We are very honored to receive such expert guidance, especially at a time when the study and practice of law have become more challenging. In behalf of Rex Education, allow me to congratulate you on yet another feather in your cap with the release of this book. We look forward to learning more from you through your books and lectures. Once again, congratulations, attorney, and here's to more years of working together as stewards of legal education.
Thank you.
All right, please be informed that you may ask questions to the speaker by typing them in the comment section. There will be time allotted for the Q&A at the latter part of the session. And to tell us more about what makes the book an expert guide and a resource in the study of law, let us all give a warm welcome to Attorney Mariko C. Iwaki, Attorney and Legal Committee Member, Office of the Regional Director at DILG Region 4A.
So, good afternoon, everyone. First of all, I would like to take this opportunity to thank Attorney Paulino Ungos III, Attorney Paulino Ungos Jr., and Rex Bookstore for being one of the people who will share their testimonial on today's book launch. So, to start, I will just want to tell you a short story as to how I met the best professors of labor law in our country. So, I entered San Beda College School of Law, academic year 2015, and during my second year in law school, I was fortunate enough to be a part of the agricultural law class where Attorney Paulino Ungos III is our professor. So, Attorney Ungos III is very considerate to his students, and he is articulate when conducting recitations, and of course, he sees to it to understand the needs of his students. And so I learned a lot from his subject, from letting us understand what CARP and CARL is. And I can say that someday, if I will be given a chance to teach, I want to be like him. So on the same year, I met the other Ungos attorney. So Attorney Ungos Jr., and I took his class in labor standards. And at first, I was kind of afraid because this professor looks tough and strict. But as the semester progressed, I realized that my impressions were wrong. Attorney Ungos Jr. was a natural joker, a professor with sense of humor, and also an excellent lecturer during class. He's always exerting an effort by getting to know his students and showed us what fairness and professionalism means. So, after taking his labor standard class, I also became his student in labor relations and labor law review during my 4th year in law school. And I can say that the things I know about labor code and the laws relating to labor up to this day is because of him. So, thank you, attorney. And what could be better than knowing that your professor is also the author of your law books? So, to everyone who's watching right now, I'm sure that all the former and current students of Attorney Ungos and those who have read their books would have to agree with me that their books in LabStan, in labor relations, and fundamentals of labor law review are the means that pave the way for us to know what labor law actually is. Their books are not only all-in-one, meaning you don't need to have a lot of cross-reference as you browse through their books, but also it is very convenient knowing that you will have the overview of the labor code just by using one material. And so I decided to stick with these materials during my bar review using the same book in labor, and I took the bar examinations last November 2019. And this is an honest story, but I can tell you that during the afternoon of the first Sunday of the bar examinations, I can hear Attorney Ungos' voice in my head telling me what to answer. And I was able to remember the terms, the principles, and interpretation of the labor code, which I learned from him during class, and of course, those I directly read from their books. And now, they have their new book, which is the Pre-Week Handbook on Labor Law 2021 edition, which is, of course, I know will definitely help law students, especially baristas and bar reviewees this coming 2021 bar exams. As I mentioned earlier, their books will give the readers an overview of the labor code. So this Pre-Week Handbook will surely remind the reviewees the important provisions, the landmark cases in labor law, and the key points to remember as they take the bar. And I actually wish that the authors released this book earlier, around 2019 when we took the bar exams, because I guarantee that this Pre-Week Handbook would actually be a lifesaver for us during the bar. But now, law students and baristas are very lucky because they can get a hold of this book as it will make their studying easier and more efficient. So I suggest that if you really want to learn labor, you need to read first the Labor Standards book by Attorney Ungos, Labor Relations, the Fundamentals of Labor Law, and for the last touch or the last piece to complete the puzzle is you read this Pre-Week Handbook. I noticed that this Pre-Week Handbook is very compact, so meaning the authors of the book really made sure that this will cover everything that you need from the hiring and selection of employees, their rights and privileges, remedies afforded by the labor code, where do you lodge your complaints, up until the termination and appeals taken in courts. Meaning, this book covers everything from start to finish. So, as mentioned also by Attorney Ungos earlier, there are also several amendments that was introduced during these past few years, which were also updated and introduced in this Pre-Week Handbook. So, to everyone who is watching right now, I highly recommend for you to get a copy of this book if you want to study and to learn labor code comprehensively and know the latest jurisprudences that we have now in labor law. So, to end my testimonial, I would like again to congratulate the authors of this book, Attorney Ungos Jr. and Attorney Ungos III, for creating this material and imparting your knowledge in labor law. And we hope that you create more masterpieces like this and help to mold or create future lawyers in our country. Congratulations again, and thank you and good afternoon.
Thank you very much, Attorney Iwaki. And now we are very honored to be joined by another legal expert who can best guide us on how we can use the book for an optimum learning, especially for the upcoming bar examinations. Let us all give a warm welcome to Attorney John Vincent B. Malinaw, Mediator Arbiter at Dole NCR Regional Office.
May pinindot ako, tapos
Good afternoon to everybody. My profound gratitude to Rex Bookstore and the authors for giving me this opportunity. First of all, I wish to congratulate the authors for their new book, the 3-week Handbook on Labor Law. It's a great honor to be here to speak about them and their new book. For the different facets of our lives, there are various people whom we consider as heroes. For me, there is Howard Schultz of Starbucks, the late President Ramon Magsaysay, and of course my father. As a student of law, and even now as a lawyer, I consider justices and authors of law books as my heroes. To me, they are rock stars and superstars in their own right. Quite honestly, I still get starstruck around them. To be in their presence, including Attorney Ungos Jr. and Attorney Ungos III, I still get this feeling that I'm around celebrities with great minds. I say this because the first thing Attorney Ungos Jr. said in our labor standard class was, "Mahirap ang labor law, but I can assure you, I will make it easy for you." I still cannot believe how true these words are. Now that I'm a mediator arbiter for the Department of Labor, these words still resonate in my ears. Their books are and will always be my primary source of knowledge on the topic. The manner of how labor laws were discussed in the book is quite unique. Simply because compared to other law books, it did not discuss labor laws in its original sequence as written under the law. Instead, all related provisions were discussed in the same chapter, which helped its readers see labor law in a more holistic manner. It really helped me appreciate labor law differently. True to Attorney Ungos Jr.'s word, the manner it was written has truly made understanding labor law easy. The uniqueness of how the book was written makes their book a different class of its own. During the time I was taking the bar, the last-minute lecture on labor law was done by a different professor. The law on labor was discussed sequentially. It really confused me because it was not how I understood and knew the law. Every minute I spent there, I felt like the knowledge I gained from the authors and their books were slipping away. So in my opinion, if you learn from the book of Attorney Ungos Jr. and Attorney Ungos III, you stick with it until you take the bar. Unlike the previous labor law review books of the authors, this 3-week handbook offers a fresh take on how review books are rated. During my law school days, my strength as a student was hinged on easily remembering case law. The inclusion of case digest in this new book would greatly aid barristers in preparing for the bar. Since the facts of the case are already laid out, it would be easier for the readers to recall cases when a similar bar question or a situation confronts them. The way the case digests were incorporated keeps the readers well engaged. In my opinion, the digest offers somewhat a break from the discussions of the law. While there is the addition of case digest, these cases, carefully handpicked by the authors, are not too numerous as to make the absorption of knowledge too overwhelming, cumbersome, or complex. One need not rely on other sources to gain knowledge and confidence in preparation for the bar exams. With regard to labor law, all they need is this 3-week handbook on labor law by Attorney Ungos Jr. and Attorney Ungos III. Before I end, let me share you a piece of history of how the author's first book came about. According to both father and son, it all began with Attorney Paulino Ungos Jr. III's notes in labor law back in his law school days. He wrote landmark cases of the Supreme Court in index cards. When he became a lawyer, these index cards were unintentionally kept in storage until it was unearthed a few years back. Realizing the richness of the material stored, the idea of writing a book came about. The same index card method was adopted by Attorney Paulino Ungos III. Through him, the old index cards of his father were updated. All that is left is to incorporate the notes and the landmark cases to the provisions of the law. And as cliche as it may sound, the rest was history. So thank you, everybody, and especially to the authors for this opportunity. Congratulations for a very well-written book. Thank you, everybody.
Thank you very much, Attorney Malinaw. Now, let us all listen to another expert evaluation of the book. Let us all give a warm welcome to Attorney Carl Joseph S. Corpus, private practitioner.
Hello, good afternoon, everyone. It's a privilege and an honor to speak to you guys about the authors and their new handbook on labor law. First of all, I would like to commend Atty Paulino Ungos Jr. and Atty Paulino Ungos III for achieving another milestone in their capacity as book authors by publishing their newest book, the 2021 Labor Law Handbook. By their collective experience in handling labor-related cases and matters, they have become experts in this legal field. This is one of the reasons why you will never go wrong in getting a copy of the handbook, be it for your bar review or for your practice. Now, remembering how it was being under their guidance back in law school, they always teach their students to study and approach the subject in a holistic manner, correlating different parts of the labor code with one or several provisions or laws to another. I remember them explaining to us that it is the only way to properly study and truly appreciate the subject. Because when you study it that way, it is only then that you will have a systematic and logical understanding of the labor laws. This is exactly how their book is composed and written. As we all know, the biggest enemy during bar review season is time. And guys, it is already presumed that the bar reviewers have already read the annotated books on labor laws during their second and third year in law school. This labor law handbook will not only give the reader sufficient time to cover the whole subject, but it will also give them enough time to memorize and fully comprehend important provisions and jurisprudence. Now, for me, during my bar review, the main material that I read and reviewed was their 2015 handbook. Same as their latest handbook, it is concise, brief but comprehensive. It is brimful and jam-packed of keywords that will surely help you during the exams. What I have noticed in their latest handbook is the addition of the latest jurisprudence on labor laws. For example, the case of Guagua National Colleges versus Court of Appeals decided last August 28, 2018. Another one is the 2019 case, Asia Pro Multi-Purpose Cooperative versus PAES. It was decided last November 2019. And another one is the case of Paper Tech Inc. versus Catando, decided last January 2020. So there are a lot more jurisprudence included in this new handbook. Don't get me wrong. This handbook is not only for bar reviewees. It is also for lawyers. For me, I regularly encounter labor concerns in my practice as I am a member of the board of directors to a few companies, one of which is a manpower agency. I am also a corporate secretary for several companies, most of which are BPOs. So having these clients, I always consult the handbook of Atty Ungos Jr. and Atty Ungos III to brush up my knowledge and for me to be able to give a logical advice whenever needed to. To end my very short testimonial, I would like to relate to the viewers that this book will not only fully prepare you, but will also help and guide you on how to rationally answer questions on labor law bar exam. It is also a worthy investment for your future practice. You can never go wrong in carrying this handbook, especially when you have clients often asking urgent legal advice on labor matters. Anyway, that is it for my short testimonial. Congratulations again to the authors and to Rex Bookstore, and more success to everyone. Thanks for your time, guys.
Thank you very much, Attorney Corpus. At this point, we will now be hearing more about how the works of Atty Paulino Ungos Jr. and Atty Paulino Ungos III helped pave the way for some of the most remarkable young lawyers today. Let us all give a warm welcome to Mr. Venich Jamin Ramzel A. Pedron, salutatorian, San Beda College Alabang School of Law, class of 2020, features editor, Bedan Law Review, magna cum laude, University of Perpetual Help System Laguna, class of 2016.
To our beloved authors, Atty Paulino Ungos Jr. and Atty Paulino Ungos III, to the officers and staff of Rex Bookstore, and to all those who took time to witness the launch of Rex Bookstore's newest book on labor law. A pleasant afternoon. On behalf of the author's past and present students, I would like to congratulate them on yet another contribution to the field of labor law education. Attorney Paul and Attorney John Ungos are one of the best and well-respected professors, especially in San Beda College Alabang School of Law. They are regarded as authorities in the field of labor law. But aside from their academic reputation, both our authors are also admired by their students for their dedication to teach the law to each and every student in the class. They teach labor law in a very simple manner, explaining the basic concepts of the law and helping students find its application to real-life situations. The author's dedication in sharing their knowledge of labor law is apparent in all the books that they have authored, from agrarian law and social legislation, to labor standards and labor relations, up to their book in Labor Law Review, The Fundamentals. It all shared the common characteristics of being simple to read and easy to understand. With that said, I can gladly confirm that their newest book, the Pre-Week Handbook on Labor Law, shares the same Ungos style of writing. Arranged on a per-topic basis, the book makes it easier for us to read and look for the topics that we need to read. It is arranged in such a way as to allow bar reviewees as well as law students to study the basics of labor law in accordance with the topics in the bar syllabus. It is straight to the point, while not sacrificing the details needed to understand the law comprehensively. With that, I can truly say that the book is very much worthy of your consideration. Before I end, I would like to thank the authors, Attorney Paul and Attorney John Ungos, for yet another gift to us law students. We know that this book is a product of your dedication in helping us achieve our dream of becoming members of the legal profession. And we are sure that this will be a big help in our quest in achieving that dream. Again, I would like to congratulate Attorney Paul and Attorney John for a job well done. And the San Beda College Alabang School of Law community is very proud of you. Animo San Beda.
Thank you very much. Thank you for all these kind words, Attorney Iwaki, Attorney Malinaw, Attorney Corpus, and Attorney Pedron. Hearing your praises of the book gives us utmost pride for having been chosen and entrusted with the publication of this masterpiece. In the same vein, allow us to express our heartfelt gratitude to you as well for being stewards of legal education and of law practice yourselves. All right. Now we're opening the floor for the question and answer portion with our authors, Attorney Paulino Ungos Jr. and Attorney Paulino Ungos III. So feel free to comment your questions below. We will be selecting 3 questions from the comments, and as we move forward, I will be reading the questions in your behalf, attorneys. All right, we have a question from Saul Velis. Hello, Sir Ungos. Question po. No bargaining agent was elected within a period of 3 years after the expiration of the existing CBA contract. On the 4th year, a new bargaining agent was elected, and as a result, they wanted to collectively bargain anew the economic provisions of the existing CBA pursuant to the automatic renewal principle. Is the bargaining agent allowed to do that? Are the provisions of the existing CBA has to be respected, considering that the 3-year period allowed for the amendment of the economic provisions of the CBA had already elapsed?
Well, the CBA can be renegotiated not later than the 3rd year of effectivity. Now,
Attorney, is it okay if you turn on your camera po? We can't see you po.
I'm having problems.
Alright po.
Hindi ko mahanap yung ano eh.
Sige, it's okay po. You may proceed with your answer, attorney.
Under the law, the CBA can be renegotiated not later than the third year of effectivity. Now, after the third year of effectivity, the CBA can only be modified or amended during the freedom period. So if the freedom period lapses without any union challenging the majority of the majority representation of the incumbent bargaining agent, then the parties can renew their CBA. I hope that answers your question.
All right, thank you very much, attorney. We have another question po from Brian Josedel Claveria D. Are the employees reinstated after an unlawful strike entitled to back wages?
Well, unlawful strike, no, they are not entitled to back wages because under the no work, no pay principle, strikers are not entitled to any wages during their strike, except if they were locked out. But if it is just an ordinary strike, we apply the principle of no work, no pay.
Thank you, attorney. We have another question po from Paris D. B. Good afternoon. What are the catch-all provisions in labor code? Thank you.
I'm sorry. What are the
catch-all provisions in labor code?
Oh, what does it mean?
That's the question po, attorney, by Paris D.
Well, what does catch-all provision mean?
What are the catch-all provisions in labor code daw po, attorney?
I hope the question can be clarified further.
All right, attorney. I will proceed to another question, attorney. From Imelda Deninia. Good afternoon, Attorney Ungos. May I respectfully ask on what is your legal opinion as to the no vaccine, no employment issue? What specific legal rights of an employee would have been violated, if any? Thank you so much for the response. God bless.
No vaccine, no employment. I think that cannot be done because that would be a violation of our rights. So it is not proper for an employer to prohibit an employee from working simply because he was not vaccinated.
Thank you, attorney. We have last two questions po, from S. Jimfer Reyes. Hi, attorney. How can we reconcile Art 136 of the Labor Code on making it unlawful for an employer to prohibit a woman employee from getting married against the case you mentioned on the validity policies of an employer against marriage based on business reasons such as trade secrets? Thank you.
It is actually reconcilable because Article 135 prohibits dismissal of employees because of marriage. Now, in the no spouse policy, the prohibition is because of certain business concerns. There are certain matters that the employer has to protect, like formulas or trade secrets or marketing strategies. So the employees dismissed not because of marriage, but because of conflict of interest.
All right, thank you, attorney. And for our last question from Hillary M. Law. Good afternoon, attorney. What if the dismissal is based on authorized cause, but there's non-observance of procedural due process? What is the employer's liability? Would the liability be the same if the dismissal is for just cause? Thank you, and in advance for your response, attorney.
With regard to due process, just remember that if the decision says that the dismissal was valid but without due process, then the liability is only for nominal damages. So in the same manner that if the dismissal is for authorized cause, if the authorized cause is adjudged to be valid, then the liability is nominal damages. But if the decision says that the dismissal is illegal but without due process, the dismissal remains to be illegal, in which case the employees are entitled to reinstatement with back wages.
All right, thank you very much, attorney. And that is the end of our question and answer portion. At this point, with much honor, join us in welcoming our partner in Champion Legal Education, Atty Paulino Ungos III.
Good afternoon. I'm here to express our message of thanks. This is for the chances, the opportunities granted to us to do what we love. In sports parlance, a chance given us to play. First is to Rex Education, then known as Rex Bookstore, for inviting my father many years ago to be part of its roster of authors. Attorney Malinaw mentioned a while back the index cards of legal principles and jurisprudence which my father saved. These the pieces of information in these cards that he also shared with me when I was still a student of law were early indications of Dad's passion to teach. Rex Education was there to support this passion in 1994. Please pardon the image quality. I just took this a few minutes ago. We also say thanks to Dean Ulan Sarmiento of the San Beda Alabang School of Law, or the school we fondly refer to as the happiest law school, for continuing to nurture our passion to teach. We wouldn't have had the honor of meeting these fine young lawyers and students whom you heard a while ago. Attorney Iwaki, Attorney Malinaw, Attorney Corpus, and Mr. Padron, all from the happiest law school. Thank you for sharing your cherished insights on the book. Now, to Mr. Pedron, Ms. Ingrid Calub, and all other candidates who will be taking the bar, we hope that you find our work a valuable tool for you to achieve your dream of becoming a lawyer. Most importantly, we express our utmost gratitude to our Almighty Father. All the platforms, the interactions, and the books wouldn't be relevant. These wouldn't have mattered without His gift of life. We will end with a reminder to bar candidates. It's a quote from one of my favorite authors, Gary Vaynerchuk. He states, "Remember, your motivation, ambition, and hunger, if matched by execution, practicality, and patience, will lead to your success." Thank you again, Rex Education, and our guests for attending this event.
Thank you, and once again, congratulations, Atty Paulino Ungos Jr. and Atty Paulino Ungos III. All right, this time, as promised, we will now be having our raffle. We will be giving away a copy of this new book. Who will be the lucky one to win the book 3-week handbook on labor law by our beloved Rex authors, Atty Paulino Ungos Jr. and Atty Paulino Ungos III. Again, reminder, we will be announcing the name of the one lucky person for this raffle wheel. If your name is called, please comment down present so we know you're here with us. We will then verify if it's you who won. However, if after 30 seconds we did not see any comment, we will be drawing another winner from our list of registrants. All right, so good luck. All right, congratulations to Miss Donna Denise Recaplaza. Once again, congratulations to Miss Donna Denise Recaplaza. Miss Donna, if you're here with us today, kindly comment present so that we can verify that it's you. We will be giving you 30 seconds to comment present on the comments section below. Once again, congratulations to Miss Donna Denise Recaplaza. Don't miss your chance, Miss Donna, and comment present on the comment section below. All right, congratulations to Miss Donna Denise Recaplaza. You have won Atty Paulino Ungos Jr. and Atty Paulino Ungos III's book, new book, 3-week handbook on labor law. All right, a Rex representative will be sending you an email on how to claim your prize. All right, once again, congratulations to Miss Donna Denise Recaplaza. On that note, we have come to the end of this afternoon's program. Indeed, it was a very productive learning afternoon with our legal luminaries, Atty Paulino Ungos Jr. and Atty Paulino Ungos III, and our distinguished guests from the field of law. In behalf of Rex Education, I would like to express our heartfelt gratitude for having been chosen as your partner in legal education. We look forward to more years of our fruitful partnership as we continue to work together to enable law students and lawyers achieve their dreams of becoming lawyers and excelling as one. To everyone who joined us this afternoon, thank you for learning with us and for choosing Rex to be your partner in learning. See you all on our next book launch and lecture. Thank you and keep soaring, Educampions.